I've got my own psychological profile rolling here. I just realized something. I didn't know this. You know, if you look at my room, it's actually meticulous. Nothing's out of place. What is out of place is just needs to be organized. You know, but I didn't realize that I unconsciously put right here under all my case filings a pairing of Barbara Walters and Antonin Scalia. I didn't realize that that's what my unconscious was doing. Do you think Antonin Scalia and Barbara Walters would have enjoyed each other? Do you think they would have been friends? Do you think Antonin Scalia would have approved of Barbara Walters' nuclear paradigm? I've seen it. It's right here. But I just opened up this book. What's the first thing it says? There are times when military exigency renders resort to the traditional criminal process impracticable. English law accommodated such exigencies by allowing legislative suspension of the writ of habeas corpus for brief periods. This is not one of those exceptions. Let's see what else he says. Blackstone explained. And yet sometimes when the state is in real danger, even this, i.e. executive detention, may be a necessary measure. But the happiness of our Constitution is that it is not left to the executive power to determine when the danger of the state is so great as to render this measure expedient. For the Parliament only, or legislative power, whenever it sees proper, can authorize the Crown by suspending the Habeas Corpus Act for a short and limited time to imprison suspected persons without giving any reason for so doing. In like manner, this experiment ought only to be tried in case of extreme emergency, and in these the nation parts with its liberty for a while in order to preserve it forever. I'm going to finish reading the rest of this. I've not read it before. Where the executive has not pursued the usual course of charge, committal, and conviction, it has historically secured the legislator's explicit approval of a suspension. In England, Parliament on numerous occasions passed temporary suspensions in times of threatened invasion or rebellion. Not long after Massachusetts had adopted a clause in its constitution explicitly providing for habeas corpus, it suspended the writ in order to deal with Shays' rebellion. Our federal constitution contains a provision explicitly permitting suspension, but limiting the situations in which it may be invoked. Quote, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it, end quote. Although this provision does not state that suspension must be effected by or authorized by a legislative act, it has been so understood, consistent with English practice, and the clause's placement in Article 1. The suspension clause was by design a safety valve, the Constitution's only, quote, express provision for experience of extraordinary authority because of a crisis, end quote. Youngstown Sheet and Tube Company versus Sayer, 1952. Very early in the nation's history, President Jefferson unsuccessfully sought a suspension of habeas corpus to deal with Aaron Burr's conspiracy to overthrow the government. During the Civil War, Congress passed its first act authorizing executive suspension of the writ of habeas corpus to the relief of those many who thought President Lincoln's unauthorized proclamations of suspension unconstitutional. Later presidential proclamation of suspension relied upon the congressional authorization. During Reconstruction, Congress passed the Ku Klux Klan Act, which included a provision authorizing suspension of the writ invoked by President Grant in quelling a rebellion in 9 South Carolina counties. 2 later acts of Congress provided broad suspension authority to governors of U.S. possessions. The Philippine Civil Government Act of 1902 provided that the governor of the Philippines could suspend the writ in case of rebellion, insurrection, or invasion. In 1905, the writ was suspended for 9 months by proclamation of the governor. The Hawaiian Organic Act of 1900 likewise provided that the governor of Hawaii could suspend the writ in case of rebellion or invasion or threat thereof. This is very important because right prior to the delivery of the verdict, following an April 24th, 2020 Supreme Court adjudication that also was in consideration of an act that had happened here in the local district court, I was reviewing a Supreme Court case that was authored, the majority opinion was authored by Alito, and it had to do with tribal determinations in Hawaii. And halfway through my efforts to read it, it changed the bandwidth. The bandwidth just changed. And what was going on when I was reading it in accordance with Alito's majority opinion was speaking very much to and resonating directly with what was actually going on in my consideration of trying to bring criminal charges. That it was that clear, it was that consistent, and I was speaking out loud. I spoke out loud while I was reading it for about 20 minutes without recording it. And then the bandwidth changed, and all of a sudden, a completely different implication, as if there was a racialized association with the identity of Justice Sotomayor, and it was no longer about criminal charges. It was about something else. And it was as if, well, what he was discussing and how he was presenting it was actually providing a foundation for consideration of specific elements of my legal argument regarding the need for criminal charges. Well, no. That bandwidth swapped out, and all of a sudden, I was supposed to not even retain. So what happened to my voice file when I did it's gone now. Somebody stole it. Now I have my written notes. That wasn't a seizure. That wasn't a seizure. That was extortion. That was, yes, actually, Justice Alito has this argument. He's put it in a Supreme Court case. What he's discussing could potentially be cited in your argument were you to be allowed into court, little lady. You're not allowed into court. You're one of those gentle cows we've associated with this ranch setup we've put into effect. And your mistress is Sotomayor. That's what they did. What ended up happening? Well, I saw what they did over the weekend. And then the Monday after, they printed 3 opinions. We're dealing with the implications of those now, aren't we? Actually, 6 months later would have been October. 6 months later would have been when there was a 20-year benchmark connected to disposal of radioactive materials that was allowed to intentionally default. That had been set up last year when I was on my blog with alarms, screaming, they're setting up a nuclear attack in our country. It's premeditated. They've got defaults happening right now. Nobody's responding. They're doing the opposite. They had all that stuff at the Federal Reserve. They had specifically set things up for a very short period of time. Things were structured on the Federal Reserve site in a very specific way. And I caught it. But this year, what happened on October 24th of this year? What happened on October 27th of this year? What happened on October 29th of this year? Where are we at now? Well, the other one he mentions, the Philippine Civil Government Act in 1902. Obama was from Hawaii, right? Yeah. Okay. Yeah, whatever you are. Who was the second head of state to receive a vaccine for COVID-19 from Russia? And what ended up happening shortly after that? There was a pardon, remember? There was a pardon of a member of the United States military who was allegedly involved in the beating death of a trans woman, if I'm correct. Am I correct? Did that actually happen? So if you look at this year, just like you should have looked at last year, the counter moves that are being made by so-called sanctionable entities, when the United States refuses to do its duty to provide for the safety and welfare of its own people, what do you see? Am I supposed to say, thank you, Senor Putin, for your insurance? Because no matter what I try to do otherwise, I'm forced to be transgender in order to have a political expression? I don't think that's acceptable. Now, one could also say that elsewhere in this book that I have read through, Scalia also discusses how it is improper and inappropriate for the Supreme Court of the United States to remand considerations of constitutional issues in comparison with the legal systems of other countries, including England, and including with an understanding there are necessary distinctions that need to be made when invoking English common law specifically, but other things associated with the English system of jurisprudence and parliamentary procedure relative to what we have in the United States as a constitutional system. One could say, well, perhaps this is conflicting in that regard. But at the same time, what is the inverse of a justifiable writ of habeas corpus violation? Suspension of writ of habeas corpus. When you refuse to release somebody and you get away with it long enough to set the material conditions in motion for justifying the illegal detention of large swaths of people. March 16th of 2017 would have been about a month after I was first put into that domestic violence shelter in Pasadena, Texas, that I attempted to report for child abuse and fraud. 3 years later, what happened? What did he say about experiments? In like manner, this experiment ought only to be tried in case of extreme emergency, quoting Blackstone. Well, emergency. What was the emergency? Was the emergency what I found when I was writing my report concurrent to the Harvard Law Review attempting publication of the magnum opus of the alleged former president? Or was it what was going on at the time that I did not know about, but ended up actually expressing cognizance of going on concurrently, which was the release of those protective action guides by the Environmental Protection Agency concerning what to do about exposure to a radiological incident, including changes related to children, and what was an acceptable response concerning exposure of children to a radiological incident. Was that the fucking emergency? So you're going to suspend habeas corpus and imprison people who have any cognizance and don't agree to take the fucking bribe? I don't think that's constitutional. You have no standing.